Victoria Lewis update. Let's get into it. All right, starting points matter. On the docket, Carrie Thompson files a notice of appearance right here, October 22nd. On the docket, this makes her the counsel of record. From this moment forward, she has the authority to act. She receives notices. She appears at hearings. She speaks for the defendant unless withdrawn or substitute, right? This is clean. This is not ambiguity here. Then on December 18th, 2024, Carrie Thompson is still the attorney of record. The arraignment occurs, right? The defendant enters a plea on behalf by Carrie Thompson, and the case proceeds in its normal posture. Up until this point, everything lines up procedurally, right? Then when you move down here on, February 7th, 2025, the Brady motion, right? Now, this is where things start to shift. Let me show you. Now, a motion for discovery and substitution of counsel is filed. All right, the first paragraph says, right, please note the appearance of Timothy L. Lamb as sole counsel for defendant, right? The key points, this is not titled notice of appearance or entry of appearance. It is embedded inside a motion, right? It assumes substitution rather than clearly documenting it, right? Courts often accept this in practice, but procedurally it creates ambiguity about when counsel formally assumes authority. This becomes important later. On the very same day, he files a leave of absence. And as you can see, some of these dates are actual holidays. So I understand why we got to put in a leave of absence for holidays, but it brings into question that you take on a case and automatically put in a leave of absence. And looking on several dockets that I've looked at thus far, it seems like when there is a question of ineffective counsel, this is one of the main tactics that they use. And being that you'll see that Victoria filed a speedy trial, and he files this is first leave of absence. He's going to file another one. It brings into question, if your defendant is filing a speedy trial, why are you filing leave of absence? And if you understand how the trial calendar lines up, some of these dates lines up with the first weeks of the month. And the DA is doing the exact same thing. But I've seen some trials where defendants seem to be acquitted, and I have yet to see a leave of absence on their docket, right? Let's get into more of this here. Stay with me. All right, just 5 days later, Victoria files a demand for speedy trial, right? This invokes statutory deadline, calendar protection, severe consequences if violated. Once filed, the case is put on the clock. The state must comply or face dismissal. This is a high leverage defense move, right? This is very important. Speedy trial belongs to the defendant. Counsel acts only as a vehicle. All right, just 7 days later, the state files a leave of absence. Now, this is common. Prosecutors also calendar around conflicts, but a speedy trial limits flexibility. Leave of absence do not automatically toll speedy trial unless properly accounted for. This is where tensions begins. Then on the very next day, Timothy Lamb files a withdrawal for speedy trial, right? This filed by the same attorney who demanded it. The withdrawal removes the statutory clock. It eliminates automatic dismissal leverage, reopens the case timeline fully, right? Legally, a withdrawn speedy trial is usually gone, right? You don't get a second bite. Courts treat it as a strategic waiver. Now, this is massive. Now, let's read this. The defendant hereby withdraws her demands for speedy trial, her counsel noting that it is in her best interest that this withdrawal be filed. Now, notice he's saying that the defendant said, the defendant is not, her signature is not on here. The key line is this, noting that, it says, her counsel, noting that it is in her best interest. Riddle me this. How taking away your statutory clock, opening the case up to a longer timeline, is in her best interest? That ultimately leads to a life sentence. Then about a month later, additional leave of absence is filed by the district attorney. Case drifts back into the normal calendar posture, no longer under the speedy trial pressure. Again, not illegal, but sequences matter. Here in this picture, you see it. Victoria is convicted. Sentence imposed, life plus 5. And at this point, speedy trial is closed. Trial phase is over. Only post-trial remedies remain. Then just 5 days later, Timothy Lamb puts in a motion for a new trial. Let's read it. Comes down the defendant and the above that on February 4th, 2026, she was convicted of kidnapping with bodily harm and aggravated stalking. She was sentenced to life plus 5 years concurrent. She now moves, note that language, she now moves for a new trial pursuant under the statute there. In support of this motion, the defendant contends that the evidence was insufficient to support the verdict and that the verdict is contrary to law. The defendant reserves the right to amend this motion, February the 9th, right? Now notice, it doesn't say no speedy trial issue. It doesn't say sealed competency issue. It doesn't say procedural misconduct. It doesn't say factual specificity, right? Why does this matter? Lawyers do not raise ineffective counsel against themselves. Filing a generic motion preserves the existence of a motion, but closes the door on issues not raised timely. Georgia law is strict on the second bites. This motion reads defensive, not aggressive. So basically, in a nutshell, by this lawyer, the same lawyer who represented her at trial, by him filing this motion, he closes the door on the speedy trial. He closes the door on ineffective counsel. And notice the timing, 5 days after conviction. Now, you have 30 days before the conviction is confirmed. But look at this motion. It's almost like this is what Victoria's saying. She said it was insufficient evidence. How would Victoria know that? And she's been in the county jail for over a year. She hasn't come home. What kind of evidence has she known? But a lot of times, strategically speaking, this is put into play to kill your appeal. And I'm just going to call it how it is. This is strategic. Because why would you leave such a broad motion to be shut down on the appeal? And guess what? Once they shut this motion down, she cannot bring up speedy trial. She cannot bring up ineffective counsel. She cannot bring up prosecutorial misconduct. None of that, because you didn't bring it up initially. And the only thing he brought up was insufficient evidence, and the verdict is contrary to law. He's covering his ass. I'm telling you, there's more. Hold on one second. So about 8 days later, Victoria filed a motion to discharge counsel. She has fired Tim Lamb. She no longer wants him representing her because ineffective counsel is not going to be filed by said ineffective counsel, right? So she has filed a motion to handle her case pro se or until she finds effective counsel. But she did file this on the 17th, and there's more. All right, here's a motion, a notice of hearing from the state Superior Court Judge Stephen Bradley on the last motion to pretty much fire her lawyer. This will be held March 16th at 9 a.m. And they're going to give a ruling on whether she can fire her lawyer, whether they can substitute the lawyer, or whether they make her keep her lawyer, right? And there's whether she can represent herself, right? But possible outcomes is they could discharge or grant the pro se or new counsel. They could discharge, deny, current counsel remains, a new appointed counsel, case continues with replacement. This here is now a hedge point, right? This isn't about accusing anybody of wrongdoing. This is about process, timing, and consequences. When you line the docket up in order, certain decisions permanently close certain doors, especially speedy trial and post-trial remedies. Now, the court has to decide whether Victoria gets to chart her own course moving forward. We're going to keep watching this, keep tracking the record, and keep letting the document speak for themselves. This is Lamar King, Senior Investigative Analyst, New Media, where the truth will never be silenced. Be great today. Peace.